Present.
Mr. Daly?
Here.
Mr. Blosh?
Here.
Mr. Glockner? Mr. Swindell?
Here.
Mr. Sanders? Mr. Horn? Madam Chairman, we have a quorum.
Thank you. Prior to us proceeding, I want to explain to you that since we do not have, Mr. Glockner is a member of the committee, permanent member, the two alternates, we would normally appoint one of them as a voting member. With 4 board members here, the decision made by the board has to be unanimous. So I am giving you the opportunity, if you want to postpone based on the fact that we do not have 5 members on the committee, then we would ask for you to do so. So I just wanted you to understand that prior to us going forward. So all of us have to agree in order to pass your variance request. So I just wanted that to be clear prior to us going forward. All right, I would ask for you to please silence all your electronic devices. If you have an appeal to our decision, you may go to the 22nd Judicial and appeal. So this is an opportunity that you have if you disagree with what our decision is based on the cases presented. There are speaker cards on either side. If you oppose something that is coming up or you have something additional to say, please fill out one of the speaker cards. We would also want you to know that there are, for the speaking, you have 5 minutes for each side and 3 minutes for additional comments or rebuttal. Once your case has been heard and voted upon, we would ask that you leave the building only because the noise carries, and as we're trying to concentrate on another case, it can be confusing for the board and also for the people in here. We want to honor their time. I would now ask for an approval of the October 7th minutes.
I'll make a motion to approve.
Mr. Swindell?
Do I have a second?
Yeah, I'll second.
Mr. Daly?
All right, I would ask that you vote, please.
All in favor, motion carries.
Thank you. All right, the first case that we're going to hear today is BOA case number 2025-4399. And it is a request by an applicant to reduce the side yard setback from 15 feet to 1 foot to allow for the addition of an existing residence. It is in a Zone L, which is a large lot residential district. I would ask the staff to please read their comments.
I received a letter, email from the owner requesting to postpone the case. So at this time, there's a request in front of the board. If you would like to entertain the request to postpone until next week.
Do I have a motion?
I'll make a motion to postpone. I'll second.
It's been moved and seconded to postpone case 4399. Would you please vote? All right. Our first, second.
All in favor, motion carries. It's okay.
I saw it. All right. The first, second case that we have today is 254404. The variance is a request by the applicant for a variance of the required 8-foot opaque screen on all sides of the property. It is the CBF Community-Based Facilities District. Findings of the staff, please.
The applicant is requesting a waiver of the requirement to install an 8-foot opaque fence along all sides of the property. The 7.003 acre site is currently being developed as a baseball training facility. As illustrated on the attached aerial image, the property is predominantly bordered by undeveloped residentially zoned land, with the exception of 2 existing single-family homes to the east and 1 to the west. Significant natural buffers exist between the eastern residences and the proposed facility. On the west side, the nearest single-family home is located approximately 18 feet from the property line and an additional 15 feet from the parking lot. The site and landscape plan indicates the planting and preservation of numerous Class A and Class B trees throughout the property and within the 15-foot required buffers. Staff do not have any objection to the waiver request, given the presence of substantial natural buffering around all sides of the property. Additionally, a letter of no objection has been submitted from the adjacent property owner. Should the board not be in favor of the requested variance, it should be subject to the construction of 8-foot opaque screen. Should the board be in favor of the requested variance, it should be subject to the submission of a recorded notarized acknowledgement stating that should any adjacent property owner request the installation of the 8-foot opaque fence along the shared property line, that the applicant or owner would construct the fence at their own expense.
Thank you. I believe Mr. Smitty Smith is representing. Come forward, please state your name and your address.
Smitty Smith, 126 Pontchartrain Oaks.
Thank you. Sir, the floor is yours.
Okay, I guess I don't, thank y'all for having me, first off. I really don't have much to add to what she said. We're developing a baseball training facility. It's going to be really good. It doesn't make a lot of sense to put a fence in the middle of the woods. It would be very difficult to maintain. There's natural tree buffers that would be growing into the fence. We'd have to bring heavy equipment in and really clear a path to actually build the fence. We have an additional 15-foot buffer on our side of the property line already, so we'd be destroying trees that exist within the property line in order to build a fence that can't be maintained at the property line. I get the reason for the requirement and think that likely if we had a neighbor that had a cleared lot or something where we could build, it would make sense. But for our project, it would be an unnecessary and undue hardship, and we're asking for a variance.
Thank you. I do have a speaker card opposing, and so would Mr. Albert Ranford come forward, please, sir.
Yes. Thank you all for being here. The Six Rings baseball planning permit was granted with the requirement for the fence. Owner attempted to get in touch to agree to me for no fence, and we told him no. Owner then applied for this variance. If you grant the variance, it is subject to if any adjacent owner requests the fence. Owner must conduct it at owner's expense as originally agreed. As an adjacent owner, I am on record as saying I request the fence, and I have done so from the beginning. I own 18 acres next to the project, west and north, 18 acres. Some of my family owns to the east, so we're border this project quite a bit. And it has to do with safety, privacy, and the woods that are there, especially by the home up in the front, one of them, it's wide open to the parking lot. There's going to be a lot of noise coming from those bats. I have no problem, but I just want a fence. I request a fence. I thank you.
Thank you for coming forward. All right, I would now have the rebuttal, if you would like to come up and talk with us about that.
Yeah, certainly. I did reach out to Mr. Rayford as well as all the property owners. He was the one property owner with an objection. And I do have pictures of the wooded area. He is right up in front. There is a narrower strip. It's probably about 10 feet. And it's been cleared from his side into the property line there. And if he wanted a fence there, I would understand that. I know it can't go all the way to the street, and DOTD and the parish have regulations of where we have to stop, but in accordance with that, I think that's very reasonable. However, just soon after that, it does become very densely wooded. In addition to that, I have an arborist report. There are many dead trees that pose a danger. We would not be able to actually store it on a fence prior to Mr. Rayford actually clearing these trees. Can I submit that to you?
Please do.
So certainly my objection's not to the fence, it's to putting a fence in the middle of the woods. I would ask if we do or required to build the fence that we have 3 requirements to that. One, that we build a fence after the trees have been removed from a safety standpoint. And it doesn't make sense for us to build a fence if it's going to be damaged by a tree falling on it. 2, that the neighbor actually maintain their side of the woods against the fence so that we don't have trees growing directly into the fence if we're going to spend all this money and time building it. And 3, there's some equipment and trailers that Mr. Rayford had on the property line or within the property. While my crew was clearing the property, he asked that they push that over into the property line. And currently it sits on his property line. We'd ask that he remove that prior to us building a fence.
Thank you.
The other photos I included are actually the northeast and east property lines or Mr. Rayford's property line.
I think you've seen these. All right, sir. Thank you. All right, Mr. Rayford, you have a chance to rebuttal this for 3 minutes.
Okay. Thank you. There's a buffer. It's a 15-foot buffer. They say, you know, that it's required down the property line, but common sense-wise, why not just put the fence on the inside of the buffer instead of tearing down all the trees to put the fence on the outside of the buffer? You know, I don't mind the trees being there. If he wanted to put the fence on the inside of the buffer, and I talked to him about this once before, it would be easy to do that. The land is already cleared if he wanted to put it on the inside of the buffer. But, you know, as he says, he's going to have to take down the buffer to build the fence. So it's, you know, it's property that's been in the family. The patent was signed by Abraham Lincoln, you know, way back when. Yeah, it's an old farm. We raise cattle and equipment scattered around. Some was on, which was where the property was my grandmother's property at time. That's why, you know, equipment is scattered around. No problem. I can move whatever's on the property. No problem. But a fence is needed for safety purposes, you know, all the way around. I mean, it's just privacy. It's commercial development. Thank you.
Thank you. All right. Let me start by asking the committee for questions.
Just one right
Mr. Blosh?
Please allow me at this time to apologize for my tardiness. I kind of got my days mixed up this time around, but do have a question for the applicant. Can you tell me, have you put formal notice into the property owner, the adjoining property owner, to give him notice of these trees that need to be removed? Is there a formal writing or anything like this?
No,
at this
sir.
point?
He was over there talking to the arborist at one point in time, but no, sir, there's not a
Okay, all right.
formal notice.
I don't know that we can compel him to do that ourselves, that this body doesn't have that authority, I don't believe, for one thing, but,
Well, I'm just asking for the variance. I mean, obviously, I have to actually build the fence if he goes back and asks for one.
Right.
I'm asking for the variance so our project's not pushed back while we're waiting on him to cut down trees.
right, I understand, okay. All right, and I think that would, if I'm just going to ask legal, just to be sure, that would be something that would have to be negotiated as a matter between those two parties, correct? That's not something that we would have oversight on?
Correct.
Okay, okay, thank you.
If I may add, I was,
Sure.
To clarify, I was just saying we wouldn't be able to build the fence with the trees there.
Right, I understand, okay.
Okay. Mr. Daly?
So on the site plan, the fence would be on the property line, or would it be on the inside of the 15-foot buffer?
It would be on the property line.
It'd be right on the property line?
Yes,
Okay.
sir. We have no interest in losing 15 foot all the way around our property and donating it to the neighbor.
Okay. All right. Mr. Swindell?
Yeah, I've got a few questions for Mr. Smith. Number one, without a fence, what age children are going to be participating at this site?
This will be mainly 8 to 13-year-olds.
Yeah, I mean, I was 8 to 13 once, and I can tell you without restriction, I'd be tracking down my loose baseballs. I would be doing all kinds of stuff. What is your plan to address, without a fence, issues of those children trespassing onto the adjacent property owner sites?
Well, we actually reached out to Mr. Rayford and offered to indemnify him, hold him harmless. We had an attorney reach out to him to do that, to address that in case somebody goes over. Certainly a fence won't stop that, because if you have a fence, you have to have gates, you have to have access, and I got about a 20-foot span along his property where the drainage goes through. That's directly on the ground, so, you know, somehow there's going to be an opening there. So we have offered that.
Yeah, that I'll tell you, that's a big concern of mine, and especially hearing that one of the adjacent property owners is opposed to this just by nature of, he's probably got several reasons, but certainly that's one of the big ones, and I would totally sympathize with that. Just to reiterate what Mr. Bloch says, you mentioned something about his trees. I don't know what accountability he's got for doing anything with the trees that are on his property relative to when and where you build the fence on yours. I think that's between you guys to work out. I will say that, as I recall, within the last 2 years, we have probably had at least one case where a property owner had to build a fence and decided to do it within his buffer, but we did not allow him to cut his buffer down. We only allowed him to cut a minimal amount of clearing.
Yes, sir, I
in order
didn't
to
say I
install
was going to
that
cut my
fence.
buffer. I believe that was added up, but.
Okay, that's what I heard you say.
I will have
is
to
that-
cut some portion of it to build a fence.
Well, I think you're going to have to. I mean, look, I'll be honest. I'm not going to vote for this. Primarily because you have an adjacent property owner that is specifically requesting the fence be built, and that's why we're here. I know that's very difficult, and I think when you go to build that fence, you're probably going to have to come, in order to cut some of that 15-foot buffer. You're probably going to have to come back to us again in order to ask for that if that's where you want to build it. I just think there's, with the bordering property that you've got and his very explicit opposition to this, I don't support supporting this. So,
Mr. Swindle, if I may.
yeah.
Certainly, would you at least allow me the variance so that we're not held up on the project and can actually approach the subject of getting the trees cut down and clearing the path necessary to clear it to build? And we will, as stated in the affidavit, build the fence on that property line. It will address the property line with the two other adjacent owners, one of which being in Florida. Very hard to get the affidavit from her.
Yeah, look, I know that this is a difficult scenario. I'm not in a position to negotiate any of that. And I'll be honest, like we get these requests a lot where somebody buys a property and then they plan something and then they come before us asking us for something that they have planned on us granting them. And oftentimes we get this similar request to what you're saying. Hey, for sake of budget and or time, can I do this or that instead of? It's a difficult spot for us to be here. I'm going to say that my only responsibility here is to say no to that, no to the request that's in front of us. The rest of whatever you're asking for has to be negotiated with others. That's not a function of the Board of Adjustments.
Mr. Woodson, what the staff said was, should the board not be in favor of the requested variance, it should be subject to construct of an 8-foot high opaque fencing along all sides of the property. With that being said, if we vote against it with that, then you would be able to go forward with the knowledge that you are going to have to construct the 8-foot high fence.
Yes, ma'am.
So if we oppose it with that construct that an 8-foot fence has to be built, then there you have it. You can go forward because we have approved it with the construct that the 8-foot fence has to be
Well,
built.
there's 2 other neighbors that I'd have to specifically seek out and get affidavits from.
Yeah, I suppose you could take that avenue also, is go track down those neighbors and a very specific support of your request. And perhaps you could then come back in front of us and ask for that. But pretty specifically, you've got at least 1 of 3 or 2 adjacent property owners that are against it. It's very hard for me to support the request as
And to be clear, Ms. Swindle, I did actually, when I called the permitting office, let them know the entire story and that Mr. Mack was not in favor of this fence.
I apologize if I intended to say you did or didn't. I was just relaying other similar cases.
We have the opportunity, if you would like to do this, you could request postponing for another month until you get the other owners' letters, etc.
Okay.
Yeah.
All right. Well, in that case, I request to postpone.
I agree with that. I'll make a motion to postpone.
I'll second.
It's been moved and seconded to
What
go.
does that mean?
It means that he has the opportunity to go and get the letters that he needs from the other people, and that he will come to us again, and we will hear the case again, and we will be able to add all of the 8 people that are involved in this, so that
So if one continues to object, is the variance going to be granted?
that's why we're postponing. We will hear this again.
If one landowner continues to object, does he get his variance?
Ma'am, I can't address that. We're going to have to hear it again. And
Sorry, may I interject? I mean, even if he's granted the variance, it still will have the condition that if the adjacent landowner requests the fence, that a fence be installed. So
Yeah.
it just would be the amount of fence, I guess. Is that fair to say?
I think you're right.
Extensiveness of it.
I think the
On
extent
which
of the
property
fence,
line?
right.
Thank you.
Yeah.
So,
And that's a product evaluated in full.
correct, yeah. So I think that we need to vote. There is a motion on the floor to postpone until
We
next
just need a
month.
second, right?
You seconded.
Oh, I did second.
Yeah. All right, it's been moved and seconded. We will now vote on the postponement.
All in favor, motion carries.
Thank you. All right, moving on, we will address 2025-4411, variance request by an applicant for an after-the-fact request to allow for replanting of the required number of trees within the front buffer as per landscape plan submitted. It's a PBC Planned Business Campus District, and I would ask for the staff findings, please.
The initially approved land clearing plan complied with the requirements of retaining all the qualified street buffer tree, all the qualified trees within the street buffer. However, during site clearing, these protected trees were removed, and any removal of the trees from a designated natural area requires mitigation prior to issuance of a building permit or work order. These mitigation efforts must occur within designated remediation areas. To address the removal, the applicant submitted a landscape plan and mitigation plan that includes replacement of trees in accordance with the Unified Development Code. The plan uses a credit-based system to match the size and quantity of replacement trees to those that were lost. Due to the constraint of the site, the applicant is unable to plant all required replacement trees in addition to the standard buffers requirement in the street buffer landscaping area. As an alternative, the applicant proposes to contribute 55 inches of replacement tree to the St. Tammany Parish tree bank as outlined in a mitigation chart included into your staff report. Staff has reviewed the proposed replanting and mitigation strategy and finds it consistent with the Unified Development Code. Accordingly, staff has no objection to the proposed replanting plan and tree bank contribution.
Thank you. Will Mr. Josh Weiner please state your name and your address?
Yes, my name is Blake Brinson. I'm with Stoa Group. We're the developer behind the project. My address is 210 East Morse Avenue, Hammond, Louisiana. At the time when we submitted for the hearing, we were simply the developer, not the landowner. In that time, we have since closed on the property, so we are also the landowner at this time. But as staff read, we had submitted land clearing plans that protected the buffers. We then sent out a surveyor to go and stake the buffers to protect the oak trees with fencing. We sent pictures of all that to staff, and I believe they walked the property as well to ensure that was all there. I brought some of those pictures today in case you all wanted to review them. Unfortunately, when we handed over that land clearing plan to the site contractor to do the clearing, they, for whatever reason, avoided the buffer stakes or did not avoid the buffer stakes and cleared the front buffer. And at that time, we immediately went to staff and let them know that we needed to take action. This was a handful of months ago at this point. And since that time, have worked with them to try to figure out the best way to mitigate this. They didn't touch the staked live oak trees, fortunately, but they did impact the buffers. And so we are here to ask for a after-the-fact variance to move forward and replant the buffers with Class A and B trees. And as mentioned, we would be overplanting, and there would be risk of the trees dying by the overplanting if we did plant the required number of inches. So since we don't think that's the proper route to take, we'd rather contribute to the bank and pay for those inches instead of risking future deterioration of the trees.
All right, thank you.
Thank you all.
Is there anyone who objects to this variance? With none, I would ask the board for comments. Mr. Blosh.
I just have a question for staff. If these are the requirements for the planting along the buffer, the front buffer and setback, do they deem this as an overplanting request?
Yes.
They do.
Yes, it was the way the plan is submitted and in the proposal. Staff has reviewed everything, reviewed the proposed replanting, also the proposed mitigation plan, and it meets the requirements. It's the best way to proceed, to make sure that there's not an overplanting as it was stated.
I guess my question mainly is focused on this requirement for the planting to begin with. Is it deemed an overplanting? Is that something that needs to be reviewed in the future for other buffer areas? Yeah, are you following what I'm saying, tracking on that?
Oh, okay. I'm sorry, maybe I misunderstood your question. So basically, is if it would be a piece of property that would already be cleared, then they could plant it according to the regulations. However, they cut large trees that have to be mitigated, which are much larger. So when you start comparing, you know, the caliber of the trees and the number of trees that have to be replanted to mitigate what was there before, this is where we get into a particular situation.
Okay, so in the opinion of our arborists, we're going to be allowing some planting that will be feasible, number one, and number two would actually satisfy what we think is.
That's correct,
Okay.
yes.
Okay, I'm good with it, Tim. Thank you.
I'm good with that. Mr. Daly?
Yeah, this location actually has a sidewalk in front of it, right? So that's part
Right.
into that buffer area. So that's kind of another item where you can't plant plants, essentially.
All righty.
More of an observation. So.
Any other comments? Do I hear a motion?
Mr. Swindle.
Oh, Mr. Swindle, I'm sorry.
Yeah, but I'll make a motion right after. I was just going to say I appreciate the fact that you owned up to screwing this up and coming back with a plan to remedy that. So in that spirit, I'd like to make a motion to approve as requested with the condition that whatever staff said here.
According to the plan that was submitted?
Yeah, according to the plan was submitted, and then contribution to the tree bank.
All right, you'll hear a second.
Second.
Mr. Bosch seconds. I'd ask for you to vote, please.
Motion carries. All in favor?
Thank you. And thank you for being progressive and addressing this particular issue. We appreciate the contribution to the tree and your foresight in doing that. So thank you very much. All right, moving along. Our next case is 4413. The variance is a request by an applicant for a waiver of the 5-foot side yard pool setback utilizing property chain wall as a boundary for the pool and decking. Variance to reduce the rear yard pool setback from 5 feet to 1 foot 0.6 inches. Variance to allow the pool and decking to be located within the bow chain drainage servitude located on the property. It is an S2 suburban resident district. And I would ask for the findings of the staff.
The objective of the request is to allow for the decking of an in-ground swimming pool to encroach into the required side and rear yard setback and within the existing Boshan drainage servitude located on the property. While no specific hardship has been demonstrated, the following facts should be considered in regarding the requested variance. Letter of no objection has been submitted by the adjacent property owner. The manager and director of Public Works for Boshan Homeowners Association have also submitted no objection letter. Should the board be in favor of the after-the-fact request variance, actually this is not an after-the-fact variance, but in favor of the variance, it should be subject to the requirement listed in the attached letter and from the Director of Public Works, which is the Director of Public Works of Boshan Homeowners Association, not say Tammany Parish. And it lists here the 5 different criteria imposed, which is also in the email and letter that is submitted. Should the board not be in favor of the requested variance, it should be submit a revised plan that complies with all required setback for the pool and decking.
Okay, thank you. If Mr. Campbell, are you representing?
Myself.
All right, sir, if you'll step forward, state your name and address, please.
Joshua Campbell, 440 Marine Oaks Drive, Mandeville.
All right, sir, thank you. Lovely area. Floor is yours, sir.
Yep. So I guess as staff said, just requesting the variance and allows me to reduce the rear and side setbacks for my yard. I do have a chain wall boundary that's the external perimeter of my yard. That chain wall boundary rises above what the elevation of my yard is. So extending to that is not, both of my neighbors are in support of that. Again, I'm within the interior of that chain wall boundary that already exists. The fence goes on top of that. I think it was mentioned that one of my property owners, both adjacent property owners have submitted letters in support of me getting the variance on the setbacks that were identified here. And then the parish not realizing in advance that the HOA not realizing in advance that I would need to come to the parish because they took the approach that was a privately owned and maintained servitude within the boundaries wholly of Bo Shin, and they do all of their ownership and maintenance, I guess, through Bo Shin Public Works. I did not come to this in advance of going to the HOA, so I think, as said, I do have the letter from them in here as well with their specific requirements. The only maybe note that I could make there is the 12-inch minimum chain wall requirement that they did place on me. We actually went back with 18 inches, so it's a more robust chain wall than what was required. So I think that was pretty straightforward, I hope.
All right, sir. Is there anyone here who objects to this? If not, then I would open the board for questions. Mr. Blosh?
The only question I have with regards to the drainage servitude, is that a servitude that's is requested or is demanded only by Bo Shin, or does that have any influence in terms of, and the reason I'm questioning this is we have to be very careful if you follow the NFIP standards for the floodplain standards. You have to maintain these drainage servitudes, or you can be in a little bit of non-compliance. So that's my biggest concern. Is this just imposed by Bo Shin? Is this aligned with the parish requirements?
Bo Shin's, all of the servitudes within Bo Shin are private servitudes that were, I guess, designed and developed by Bo Shin. That's why we got the letter in here from them supporting the encroachment on their servitude.
Okay.
And then it's even on the back boundary line, it's not an adjacent servitude to a non-subdivision boundary. The parcel that's behind it is part of the subdivision. So it's wholly encompassed within Bo Shin.
Right, and I would understand, and I appreciate what you're saying.
Yes, sir.
My concern is that you have to meet certain requirements for drainage when you're building, mm-hmm. and that servitude was set up for a reason, obviously, right? To protect something.
Yes, sir.
Your neighbors, something along that line. So I'm just wondering if that's going to create any sort of problem or issue for neighbors or for the bigger, broader plant. Because as you know, when you stop water, it has to go somewhere, right? Yeah. What is the implication of where it's going to go from there? That's my question, I suppose.
So no water, per the plans, no water is being stopped from passing through the servitude. There is a 15-inch culvert with 3 12-inch inlet basin drains that are required. The 3 12-inch inlet basin drains, it would require 72 inches of rain over a 24-hour period to overcome the intake ability of that drain. And with the external chain wall being above the elevation of the yard, no water can drain off the property. Everything would be caught into the drainage basins and then flow through the natural drainage that's allowed to proceed through the property.
Okay.
Through the property, sorry.
Mr.
So the drainage physically is not obstructed. The drainage servitude is not obstructed. The only request is the decking, the pool and the decking that's above the drainage servitude. It could present maybe a flood risk if you had nowhere for the water to go. The risk could be it would overflow onto Roger Storm Road that is behind on the parcel behind us. But with it being encompassed inside of a chain wall and the catch basins being designed by Bo Shin or per the requirements, 72 inches of rain in a 24-hour period, mm-hmm. we would have other problems if we got that much.
I understand.
Yeah.
Okay. No, I appreciate that. Just that's, we have to check these things for sure. Okay.
Ms. Lambert said that when Bo Shin started building, et cetera, it was in conjunction with Parish Code as they put everything together. So technically, while it is a gated community and a private community, mm-hmm. it was in conjunction with Parish Code and mm-hmm. Parish.
Mm-hmm. Okay, no, I understand.
And to clarify, the only reason why the owner is here and requesting a variance is because it is a private servitude, because if it would be a parish-maintained servitude, it would not be allowed.
Right, okay, I understand.
All right.
Okay.
All right, are there, let's see, Mr. Daly.
Yeah, I guess this is more of a question for staff. The if we were to approve this and make it subject to the requirements for the Beauchene Director of Public Works email, isn't that really a Beauchene thing, not us? I mean, we could approve it and Beauchene could reject it, kind of thing, and vice versa. I mean, essentially, it's nice to sort of include those, but I don't think that we really enforce any of that, right? Because that's sort of a Beauchene process.
I would just clarify that you all are only enforcing the variances in
Just-
our code. That's
yeah,
it.
yeah.
And Beauchene could reject it based on their own servitudes that
Right.
exist. So you all are simply looking at the variances as they relate to the rear and side setbacks.
Yeah, I guess I view that more as context rather than
Right,
Right.
exactly.
a stipulation we necessarily have to add.
Yeah, you can use that as a basis of evidence for denying a variance.
Okay.
But in terms of actually enforcing that servitude, that's between.
Right, that moves to a Beauchene
and the
issue.
property owner.
Okay.
Okay. All right, any other questions? Then I'll entertain a motion.
I'll make a motion to approve as submitted.
Do I have a second? I'll second that. It's been moved and seconded to approve as submitted. Let's vote.
Motion carries. All in favor?
Are we invited to go swimming?
When the project finally finishes, everybody can come.
Okay, thank you.
neighborhood's counting on.
Thank you very much. All right, our next is 4419, and it is a request by an applicant for an after-the-fact variance to... Yes, please.
No, Mr. Daly's got a call. He's got
Oh, I'm sorry, is it 3 o'clock?
So we're going to drop out for one.
All right. So what do we want to do?
Can we recess and reconvene, or?
Yes.
Okay.
Absolutely.
All right,
Try to make it as fast as you can.
all right. So I just wait till he comes back. All right, we're going to be at recess until Mr. Daly finishes somewhat of an emergency call here. Thank you. Thank you for your patience. We'll go ahead and start again. We are now going to look at 4419, the request by an applicant for the after-the-fact variance to reduce the front yard setback from 25 feet to 2 feet. Ms. Helen, would you please read the findings of the staff?
The objective of the request is to allow for a 529 square foot carport addition to remain 2 feet from the front property line. No hardship has been presented to justify the support of the requested after-the-fact variance. Should the board be in favor of the after-the-fact variance request, it should be subject to submitting the required plans for the addition of the carport to the building permits office. Should the board not be in favor of the after-the-fact request, it should be subject to removing the addition.
All right, thank you. Ms. Nanette Thorne, would you please step forward, state your name and your address, please?
Nanette Thorne, 213 Driftwood Street, Mandeville.
Thank you. Now, the floor is yours, ma'am.
I'm just trying to get a permit today to meet the requirements to continue my carport.
Okay. Anything else? You did not obtain a building permit prior to?
I did not.
Were you unaware that that would require
I really
a
don't know why
permit?
that wasn't, I don't know, but it should have been done, but it just wasn't.
Okay. All right. Anything else you'd like to say? We do have pictures.
Okay.
And we have your plot. So is there anyone who objects to this variance?
Well, I did get signatures from everybody that lives around my house, on my block.
We would like to see those, please.
Okay.
So in staff comments when it says, while no objection letters have been provided. So apparently we do have. So you're saying that these signatures indicate that there's no objection to what you're doing?
Yes, ma'am.
Okay. Okay, I'm going to open the board for questions, please. All right, Mr. Swindell.
I think without letters of support from your neighbors, I have a difficult time just approving this request on the surface. I realize that you have signatures on a piece of paper. It's very difficult for us to ascertain that those signatures are definitely for what you're asking for specifically. I would like to make a recommendation that she postpone so she can get that definitively for us before proceeding.
Okay, I can do that.
So,
That being said, I would like to make a motion to postpone.
all right, is there a second?
Second.
It's been moved and seconded to postpone. You need to get letters of approval from, of no objection from your neighbors. And
No.
there's no homeowners
No.
association here, right? I've been in the area, so I know what you're saying, that there's no formalized HOA. So you would need the,
Letters from my neighbors.
yeah,
and
but
not
it
just
needs to
signatures.
state, not just a signature.
Okay.
It needs to state that we have no objection to this particular
Okay.
structure on this street.
Okay.
Okay.
Look, I'm sure Ms. Lambert can give you examples of similar letters that other people requesting similar things have gotten in the past.
Okay, so it's been moved and seconded that we postpone. I need you to vote, please.
Motion carries. All in favor?
All right. Thank you, Ms. Thorne. Hopefully next time it will not be this long. I apologize. All right. All right, we saved the best for last. All right, so this is 2025-4369, the request by an applicant for an after-the-fact variance to reduce the required side yard setback from 5 feet to 0.9 feet for an accessory building to remain on the property. It is a single-family residential district. We have, in fact, heard this case before, and so would you please step forward and state your name, please?
Yes, Brian Glorioso on behalf of Mr. Glass. So as you mentioned, the board granted the variance. There were two conditions on that. And so we appreciate the granting, and we did try to find a way to do these conditions. But after doing additional research, it's become clear that the conditions are, in fact, legally impossible, because the condition asked us to get a letter of approval from the utility company. And in fact, there is no utility easement here to a company. So it's just, telco was written in as a placeholder, potentially for a company, but that's not an actual company. And to get a letter, I would need to have someone to go get it from. And the same thing was, I can't file suit and get a judgment in court because you have to have a party to sue. So I think obviously the intent of the board was to make sure that we weren't interfering with somebody's actual easement. I went back through and did additional research, and in fact, the easement itself that's on everybody's lot in here was part of the building restrictions of the homeowners association. And that is in Exhibit 8 that we submitted. We actually did get a letter of approval or no objection from the homeowners association. So to the extent that what the board wanted was to make sure that a person who potentially had an easement didn't object, that is in the record, but it's the homeowners association. There isn't any legal utility to get one from because it was just a placeholder for potentially, and this is back in the 70s. So I think to the intent of what you wanted, everything is in the record, and it was just some confusion about whether you know, when we went back and checked to make sure, like AT&T or even back then Bell South didn't have any utility easement, and there isn't one of record. So I think what you actually wanted is in the record now, and we did go back and clarify it. So all we're asking you to do is just amend the granting to take those conditions out that we can't otherwise legally get, and then our client will go and get the permit after the fact, and he's already gotten all of the documents to show that the drainage was all done, and he'll get that all done. So we're just asking if you could remove those conditions based upon the evidence that's submitted and the fact that there isn't any way for us to legally comply because there isn't anyone to go ask for it.
Yeah. Emily.
And yes, the planning department had asked me to look into this, and I just want to point out that there is no requirement that we get a letter of no objection from a servitude holder, but I do also want to make it clear on the record that if there is an entity or a person that has a servitude, the decision to grant the variance does not in any way affect their right to assert their servitude. You all are only granting a variance as to the setbacks in the St. Tammany Parish Code of Ordinances.
That's correct. Thank you.
Okay. So is there anybody here that opposes? Apparently not. I will entertain questions from the board or ask for a motion. Mr. Blosh.
I'll move that this be accepted as approved.
So if you,
I mean, as submitted. Sorry.
I'll
I'm not-
only second if you add that we're retaining the applying for the building permit and the drainage plan.
Yes, that was our intent. That's what we
stipulations.
asked for.
Okay.
Yes.
Absolutely.
so just to clarify, I think it would be, if you can just clearly state that you're voting in regards to 2025-4369, and the motion would be to approve the setback as requested.
Absolutely. Mhm.
That's what he said.
That's exactly what I said.
Is there a second?
He's affirming your reading of the,
Absolutely. Mhm.
So it's a motion from Mr. Blosh and seconded by Mr. Daly?
yes.
Correct. I would ask the board to please vote.
All in favor, motion carries.
Thank you very much. Appreciate it.
Thank you.
Thank you so much.
Nice to see you again.
So yes, all you need to do now is just go to the parish and submit for your permit, and then bring this to them, and they'll do the drainage plan, and you'll pay your, whatever you call it, the permit, and you're good to go. Thank you. Hey, good to see you.
Good to see you
Thank so
too.
much.
Thank you, and thank you for your patience. Okay. All right. God. I'm leaving next month. Okay, I'm sorry. Is there any old business? If not, then our next board meeting will be, drum roll please.
December 2nd. We already have 5 cases on the agenda, plus the 2 that were postponed for today. So, look, and Mr. Daly is not going to be here. So,
Right.
I'm looking for the calendar itself here.
I am.
Yes, December 2nd at 2 p.m.
Here.
Almost left my briefcase.
Uh-oh. We had already gone through it. Very interesting.
Nothing you want in there, I guarantee you that.
That was the consensus of the board. We don't want to look at this. All right, let's go to December the 2nd. Okay, that's, I don't have anything, and I don't have it unless I'm.
Regular Tuesday, yeah.
Yeah, it's our regular Tuesday.
Hopefully, Mr. Glockner will be here,
Oh, please.
and we'll just need a motion to adjourn.
Just real quick, there are 3 seats on the BOA that either have expired or need to be reappointed or will expire at the end of December. So those may be on the council agenda on December 4th for reappointment, just to make you aware. Ms. Thomas, Mr. Glockner, and Mr. Sanders.
But Ms. Thomas's doesn't expire until after that.
Anyone whose seat has expired continues to serve unless and until they're replaced by law.
Mine actually was up last January, and so they just never voted, so we'll see.
Do we need to show up and support?
Maybe. I don't know, the way the parish council meetings have been going.
I will need this.
Yes.
One of the alternates and the regular members, they were trying to reestablish staggered.
Yeah, but I don't know if they've nominated more than one for each
So,
Yeah.
so once they're reappointed, they can be reappointed.
Time will tell.
So yes, it should only come up one each year.
Okay, is there any other old business? December 2nd, everybody on everybody's council except, of course, Mr. Daly, who apparently has a phone call. But I'm just teasing. All right. Well, with that said, do you hear a motion to adjourn? Second?
Second.
Okay. It's been moved and seconded to adjourn. Meeting is adjourned. Or adjourned. And I